In part 1, we studied the environment existing in India during partition, which led to many difficult decisions with respect to Jammu and Kashmir. Today, we will go through the environment that existed from promulgation of the articles in 1950 till their removal on 5th August 2019. We shall see in detail the process followed by Modi government to repeal these acts. 31st December 1947, Nehru went to United Nations and filed a complaint. 21st April 1948, UN resolutions were passed. 31st December 1948 was decided as ceasefire day and forces were required to maintain the line of control. At first, Pakistani soldiers as well as all those who did not belong to Kashmir were to withdraw from occupied Kashmir. Then, Indian soldiers were to withdraw and thereafter plebiscite was to be held. On 31st December 48, ceasefire was achieved. 35% of Kashmir was occupied by Pakistan. Since Pakistani soldiers have not withdrawn, even till today, the conditions of plebiscite remains unfulfilled. January 1949, Sheikh had become central and Hari Singh had gone in background. Delhi understanding was reached between Sheikh Abdullah, Nehru and Patel to include Jammu and Kashmir provisions in the Indian Constitution. Sheikh, along with some others, became members of the Indian Constituent Assembly. Article 370 was incorporated. Article 370 gave special status to Jammu and Kashmir with respect to applicability of Indian Constitution. Only Article 1 and Article 370 were made applicable. Indian Parliament were free to make laws only with respect to three subjects, that is defence, communication and foreign affairs. For all other subjects, they needed a ratification or concurrence from the Jammu and Kashmir State Assembly. It was agreed that Jammu and Kashmir would have a separate constitution and a separate flag. Those who wish to read original text of Article 370 in detail may pause the video and read it. January 1950, Article 370 came into force along with the Indian Constitution. In 1952, Delhi Agreement was signed. King and Prime Minister were now to be called Sardar-e-Riyasat and Wazir-e-Azam respectively. It was also agreed that there will be no disturbance of demography of Kashmir. In 1953, Karan Singh, son of Hari Singh, was made Sardar-e-Riyasat. From 1950 to 1953, Sheikh Abdullah had started bargaining and also talking to Pakistan. At Nehru's behest, Karan Singh dismissed Abdullah's government. In 1954, the President of India issued the Constitution Application to Jammu and Kashmir Order 1954, through which Indian citizenship was extended to the residents of the state, and simultaneously the Article 35A was inserted into the Indian Constitution, enabling the state legislature to define the privileges of the permanent residents. No outsider was permitted to buy land or become eligible for many other rights in the state, like government jobs, scholarship or voting rights. It also said that if a woman of Jammu and Kashmir married outside, then she would lose her permanent residency. This was, however, later removed by High Court of Jammu and Kashmir in 2002. Those who wish to read original text of Article 35A in detail may pause the video and read. Order of 1954 was amended many times. By 1959, Nehru realized that it was easy to change things, especially when both state and centre had the same government. Same year, he got the Jammu and Kashmir Constitution amended and Election Commission was made applicable in Jammu and Kashmir. In 1964, Nehru amended the 1954 order and applied Article 356 of Indian Constitution in Jammu and Kashmir. In 1965, Shastri also amended multiple times and the names were reverted to Governor and Chief Minister. From 1953 to 1975, Jammu and Kashmir had Congress rule in state as well as centre. If they wanted, they could have repealed Article 370 and other special provisions. Best time to do so was between 1953 to 1962. After 1962 till 1975, although Congress was in rule at both centre and state, there were many compulsions for not repealing the special provisions because of the following reasons. 2 wars had crippled India's economy. 2 prime ministers had died. In 1967, Indira Gandhi came to power but with coalition support. In 1971, Indira Gandhi called for early elections. She withdrew all the powers of Rajwadas through an act of the parliament, where Congress now had a clear majority. Third war was fought with Pakistan, in which Pakistan faced a humiliating defeat. In 1972, India and Pakistan signed the Shimla Agreement, whereby they agreed to no third-party interference in their mutual matters, including the United Nations. India claims that this agreement nullifies the demand of plebiscite. In 1972, Sheikh Abdullah realized that he could not depend upon Pakistan, especially after the defeat, and started tilting back towards India. While in London, he made a statement that plebiscite was now not possible. Between 1972 to 1975, talks were held between Indira Gandhi and Sheikh Abdullah's representatives. From 1975 to 1982, Sheikh Abdullah became the chief minister. In 1982, Sheikh Abdullah died. In 1984, Indira Gandhi died. In 1986, there was onset of militancy. In 2014, Narendra Modi's manifesto stated a repealing of Articles 370 and 35A, which they achieved in 2019 after they ensured that conditions at the state and parliament were favourable to repeal these acts. Finally, coming on to the 5th of August 2019, in one day, these acts, that is Article 370 and 35A, were removed and Jammu and Kashmir was made into 2 union territories. Jammu and Kashmir Union Territory got state status like Delhi, and Ladakh was made into an independent union territory. 2 months after its poll victory, the BJP government moved 2 resolutions in parliament on that day, neither of which scrap Article 370 and yet effectively end the state's special status. It did so without having to pass a constitutional amendment which would have otherwise required a 2/3 majority in both houses. Instead, a simple majority sufficed. How exactly did the Modi government pull this off? The answer is actually something that happened outside of the parliament and not within it. Before, Home Minister Amit Shah even tabled the resolution to hollow out Article 370, a presidential order was issued to amend Article 367 of the Indian Constitution. How was this amended through an order and not an act of parliament? We will get to that later. First, it is important to understand Article 367. Article 367 is meant to act as a guide. It helps the interpretation of certain laws. If you are able to alter 367, in some case, you can change other provisions without having to do so directly, because you simply change their interpretation. It is to this article that the presidential order adds a new clause to help interpret provisions applicable to the state of Jammu and Kashmir. This clause alters the interpretation of Article 370, switching out the words Constituent Assembly with Legislative Assembly to Clause 3 of Article 370. Why does this matter? Clause 3 of Article 370 made it clear that if the President wishes to change anything within Article 370, he needs the recommendation of Jammu and Kashmir's Constituent Assembly. But the Jammu and Kashmir Constituent Assembly was dissolved in 1957, so it could not possibly give a recommendation. The presidential order changes that language to make it the Legislative Assembly rather than the Constituent Assembly. Still, the clause mandates that the President get the approval of the Legislative Assembly. But Jammu and Kashmir doesn't have one right now, since it was dissolved in 2018 and replaced with first Governor's rule and then later President's rule. So how did the government get around that? When a state is under president's rule, the power to make laws for the state is vested in the Indian Parliament. Jammu and Kashmir is currently under president's rule, so effectively the government's move allows Parliament to act on behalf of the Jammu and Kashmir Assembly to change the character of the state. This, however, raises several questions on the effect of such amendments on federalism. Amending the Constitution. Now we come back to the question at the start. Can the Indian Constitution be modified by the President by using a presidential order? Would it not require a constitutional amendment bill with two-thirds voting in its favor in Parliament? This question has been answered by the Supreme Court in 1961 in its judgment in Puran Lal Lakhanpal versus the President of India and others. The court said the term modification as it appears in Article 371 gives the President powers to effect substantial modification to the provisions of the Indian Constitution that apply to Jammu and Kashmir. This quirk of Indian law means that the Constitution can actually be changed without having to pass a constitutional amendment as long as it only deals with Jammu and Kashmir. The changes introduced on 5th August apply to Jammu and Kashmir alone and not to other parts of the country. One final question may arise. If the Constitution as it applies to Jammu and Kashmir can be changed without a constitutional amendment bill in the Parliament, why not just use that method to change Article 370? This is because the one exception to this constitutional quirk is that it cannot be used to change Article 370 directly, only other provisions. Or in other words, the government used powers under Article 370 to alter Article 367, which then in effect allowed it to hollow out Article 370. There were people who came out in full support of this order, and then there were others who condemned it. There were many who were not happy with the undemocratic way the article was so hurriedly repealed and condemned the precautions taken in the valley like switching off of internet, deploying of additional troops, etc., and the manner in which Kashmiri political leaders were detained. Those supporting the decision of the government feel that Jammu and Kashmir situation will now improve. All this means there will be no separate constitution, no separate flags. Indians from other states can go and participate in the administration and economy of Jammu and Kashmir. It's a win-win situation for Kashmiris and Indians. With increase in outside investment, land prices will increase, economic development will take place, education opportunities will increase, youth who was hitherto engaged in terrorism or militancy will get employment and can hope for an improvement in their quality of life. Further, when Kashmiris come under Indian laws, they would be able to take benefit of all Indian government laws like RTI, IT Act, etc. Kashmiri Pandits would also be able to return to the valley to their rightful homes. With one flag and one constitution, even psychologically, people would feel well integrated within India. Was it difficult for India Independence Act to have included the princely states into either India or Pakistan? Some scholars argue that existence of all these states which did not have their armies and were bound to the Indian subcontinent through network of railways, canal, power, etc. as independent states was not possible, so there was a case for Britain to force the division of these states into either India or Pakistan. History of the Indian subcontinent would have perhaps been different, especially for Jammu and Kashmir. Even otherwise, India did well in integrating more than 95% states into India. The decision of the British government of princely states deciding on their own ultimately proved advantageous to India. Could Sheikh Abdullah and others who were part of the Delhi Understanding in 1949 have ever meant that Article 370 could be repealed in a manner as happened on 5th August 2019? Many believe that the repeal would have been more acceptable had elections been held first and then Jammu and Kashmir Legislative Assembly concurrence taken. the constitutionality of this repeal is likely to remain controversial. However, it is a common practice across the world that in matters of territorial integrity of a nation, sometimes idealism, liberalism, statesmanship, and constitutionality need to take a backseat. Article 370 is linked to the story of integration of India. Many princely states were integrated with a lot of promises which were later broken. Although there are more than couple of dozen cases in the Supreme Court against the arborication of Article 370 and 35A, the judiciary is expected to exercise judicial activism in the larger interests of the country and resolve these cases in favor of the government. Thank you.